For today's session, this is Siddharth, my co-mediator. We have been mediator for the past 10 years and we are certified mediators from Bangalore Mediation Center. So before we begin, let me share a quick example of what mediation actually is, which you might like to do. So imagine this, in a cricket match, the two teams, they represent the parties present for today and the umpires represent the mediator. So the umpire steps in, listen to both the sides to clarify the rules and resolve situations which arise fairly, ensuring the game continues smoothly for everyone. So let's proceed. I'll just give you a gist of confidentiality voluntary process. So this session, mediation is very voluntary when both the parties have agreed to come here and get withdraw and implement the right to provide common agreements. So mediation is confidential. Anything we discuss, whether in the joint session or in the private session, is going to be confidential. This should not be shared or leave this room. As well as, however, I would like to also mention that we are mediators and we are not judges or arbitrators. We are not going to give you any advice or any legal or ethical decisions about your case. So our job is simply to help you work towards resolutions that make sense for both the parties. So now I'm going to, I'm going to take the parties through the mediation process. So the first thing is we're going to be starting with the open statements. First, the requesting parties line, and the council will share what brought them here today and what they need to achieve. The respondent will have the opportunity to do the same. Next, we'll move into a joint session, exploring key issues, discussing about issues and solutions that can be forward. Next, during the session, in case any of the party feels required to have rights of office, you can put forward to the mediators. As well as if as us as mediators, if we feel like during the session, the discussion is not very getting out of track. This might be not go right office. And typically, can notify from the law and work towards establishing that both the parties feel comfortable. So let's set some ground. Let's be respectful to the other. Let's not interrupt and one party speak. They're not going to say each other. Find a solution.
We are not just here to decide whether to divide the property or not. We are here to try and preserve something far more valuable. Yes? What is the value? What is the valuable thing here? The legacy. Legacy of, and please, if you don't agree with me, please don't say it. The legacy of your parents, the unity of your lineage, and the potential of future. And one more important I'd like to say is control. That means you have control over the session, not me, not my committee. With that, I'd like to ask a request if I could start with the
Before we begin, parties, please do mention your name and how you would like your address. And then.
My name is Sanjay. I would like to report to the first name itself. I have full discipline capacity.
Myself, Mr. Bond. I'm a senior legal counsel of E&M Legal Services in India, and I'm here in advisory capacity. And I would like to be addressed as Mr. Bond, or for the benefit of the second as Mr. Counsel.
Amaro, and also on behalf of Meera and Dev. I do not have the full capacity, but all the major decisions, yes, I can take those.
I am the counsel representing Mr. Amaro, Meera, and Dale. I am here as a mere advisor, and I'm Chinmay advocate, and refer me as Chinmay. I would like to mention that you are on top of that. Thank you for the amount of effort put into making us understand how the cost of mediation works and how it takes place. Obviously, it's our first time. We've never done something like this
we're in a tough situation right now. The tragedy that has struck our family, our parents, we lost in a very horrible car accident. And it's left a huge void in our families. We, all of us, we collectively feel very lost without them because they were the guiding light in our lives. We have come to this position. We have come to this position. We've come to this position because of them, because of what they provided us. So, I want to be clear, according to my counsel under the Hindu Succession Act, all five of us, Arav, Meera, Dev, Priya, and I, are entitled to equal shares in the estate since our parents left us no will, unfortunately. No amount of emotional sacrifice, financial input, or verbal promises can override this legal right. Equal inheritance is not negotiable, and we will not accept any attempt to dilute or dismiss our share. Second, we demand complete transparency and accountability in the handling of family assets, especially IF Textiles Private Limited and the commercial complex as well. Blocking day one of financial records and restricting access to the business was unjust and unfair. It was unproductive at the same time. See, all citizens deserve full access to these records so that decisions are made with mutual consent and dignity and clarity as well. Any prior misuse or mismanagement, including my own borrowing for the business, should be addressed openly and resolved within a structured and lawful framework. Third, we are open to an equitable division of assets based on current needs and past damages, without compromising on our legal share. Priya, she's a single mother, facing financial strain. She seeks a fair portion for Mumbai apartments, not as a favor, but as part of her rightful claim. Okay? I acknowledge my financial mistake and I'm willing to discuss it, for repayment or compensation of any form, but that cannot be used to erase my stake in the estate. See, we're not given a prolonged conflict of any sort. We're here to fully resolve it, guided by law, fairness, and reason. See, I want to urge everyone present here to move forward with the same intention. Thank you.
First and foremost, before I start speaking, I would like to thank the mediators for explaining the cause of mediation and how it benefits the parties for them. With that said, I would like to say that I represent Mr. Sanjay and Ms. Surya in this matter concerning the election of the state of their late parents, Mr. and Mrs. Martin. The dispute arises in the absence of a bill, and therefore the governing principle is very clear under the SSA. Each of the five legal heirs is entitled and equal 1/5 share in the estate is what our view on this issue is. Our position is not grounded, position is not grounded on personal sentiment, but in legal entitlement and the need for transparency, equity, and fairness. The clients have made it known that they are open to flexible asset or distribution provided it respects their full legal share. They are willing to cooperate and restructure the business through a family trust, subject to proper audit and financial. So, moving forward, I would like to put forth 3 points that we would like to address in this particular session. First is, of course, equal legal entitlement of all the estate assets must be acknowledged upfront. Secondly, is the full financial disclosure and independent audit. And finally, is the recognition of the current financial needs and past damages. My clients are not here to debate or betray the process. They are here to resolve it effectively, lawfully, and with dignity. We look forward for a constructive dialogue and concentrate proposals from all sides. With that said, I would like to also put forth that I have dealt with the thorough of my experience on property disputes. With that being said, I do want to put forth that any decision that we take here today from both the parties aspect, it should not affect your relationship as siblings. See, two people have worked and two people have grown together. So any decision that is taken today should not affect that relationship. Because at the end of the day, you are siblings. You are born to the same parents. You have that whatever decision you do. With that said, I will like to hear your perspective on it so that you have a better clarity on what you're doing and what your perspective is.
Okay, hi, I'm Aro, and Firstly, I'd like to thank the mediators for facilitating this discussion. Your presence over here means a lot to us as siblings as well, because we did not think we would come to such an extent where we'll have to settle this through mediation. We are not going to fight, honestly. That's very obvious. We also want to reach to an agreement. But that should be fair. It should be based on facts, efforts, and truth. This is not just a property matter, but it's about honoring what our parents built and their legacy. When they passed, we were just left with 50 crores estate and no will of such sort. In that moment of shock and grief, I was the one who took charge, and I gave up my career abroad to lead the family business. It wasn't easy, but I had to do it for my family. Meera, though she lived abroad, stood by us, paid over 1 crore for our parents' medical care without asking, without hesitation. They managed the commercial complex from day one. He ensured it stayed functional and profitable for the family. That income didn't come just from luck, but it came from his hard work that he had put in to the complex. We are not going to take more than what's just fair, but it must also reflect the reality as to what we have given to our business, to the family as such. Equal shares without recognizing who actually ran the business, paid the bills, and held the things together would deeply be very unjust. We are aware of Ria and Sanjay's rights, but we must also acknowledge that Sanjay took 2 crore from the from the business he secreted, causing a serious financial blow. Ria speaks of a verbal promise, but there is no evidence. Meanwhile, the three of us carry a whole weight. Still, again, we're not here to blame each other. Instead, I want all of us to get whatever we want in an equitable and just manner. But that can only happen if everyone's effort is honestly recognized. I would now like my counsel.
Good afternoon, everyone. Firstly, I would like to thank the mediators for making us feel comfortable with sharing all our issues and concerns. I would like to begin with saying that I deeply mourn for Mr. Nair. With that said, I would like to say, bring out the fact that Mr. Farooq and Dave, like our clients, have sacrificed their careers into running the family business. This sacrifice needs to be brought in recognition. No doubt, HSA provides the youth with equal rights in inheritance, but at the same time, we must acknowledge the difference between active contribution and passive inheritance. So now moving on to what our main agenda is. So we have three main concerns that we would like to address. First, the business and commercial complex distributions. Secondly, it's the estate distribution, which also includes the 16 crore investment, current value will be 14 crores. And finally, Veera's reimbursement for 1 crore medical expenses. With that being said, I'm happy that you have chosen mediation because with my experience, litigation takes a lot of time. I've seen cases running from 1999 in partition matters, and I've also seen how it has deeply affected the blood relations. At the end of the day, like the requesting party, I would hope that this blood relation between the 5 siblings will survive. Thank you.
Yeah, but give us more clarity on the last aspect, my dear friend council has said. Could you just repeat, what were the concerns for distribution of commercial property, reimbursement of that 1 crore, and I'll just go to that one.
The first is the business distribution. The two businesses, that is Mr. Nair's clothes business and the textiles business, and the other is the commercial complex.
Right.
And estate distribution includes 12-acre ancestral property in Kerala, 3 luxury apartments in Mumbai, commercial complex. And this commercial complex, I am including it in business distribution. That's the first agenda.
Could we add that to escape for better clarity?
The reason why I added it for business institution is there has been fully managing it from day one.
Well, so your agenda are first thing about the education business. Yeah. Second is the escape issue and the reimbursement of the one.
Yeah.
Yeah, let's confirm what the interesting part of the one is. Confirm what the
Yeah, we have four voted by both parties. First is about the business contribution. The second is about the estate distribution. And the third is about the medical expense covered by me. Is there any parties who have to add or go?
Our agendas were that we want complete transparency, accountability and the family assets, especially the business, which is not itself like limited. Equitable division of assets based on current needs and past damages, and as well as equal division of all the assets of the family.
No changes as such.
Yes. That, let's move on to the advanced channel. Before we start, advanced I just like to work my experience. There was lots of family, there was a refuge for Nigeria, not that hard. The father like this, there was, he died in the property down into. Similar case I had. There, he came in again to, the option of order background. Then we are very something. And legacy should not just be about valuations, but about values. I hope you reflect upon it. You may start this. I think Mr. Sanjay will be in a better position to start with us now because he is the applicant party. So Sanjay will just share a few words.
So I think that I was not mentioned about the division of the assets. Obviously, we've been left to go with, and we have no idea exactly how we will divide the assets. Because we have five siblings that have been together, and we have to think about a lot of such us having this relationship forward and not have to do it because of something such as division of assets. So many other families that are in such businesses end up completely disjointed and disoriented or something like this. So I want to hear from the other side what you will do for first. So according to that, whatever ideas that we have, we can put forward. So please.
So if I may, so the first is the 12-acre ancestral property in Kerala. So this one, again, we will follow the SSH, 1/5 for each person. But in this, the three parties would like to physically own this 12-acre land and hope that they can compensate you in terms of liquid cash of how much ever the value is of your share.
So just to get a clarity, so will be shared 1/5, and the other party, the other siblings, they want to buy out my party share, and I have to finish.
Secondly, in terms of the luxury apartments in Mumbai, we understand Ria's concerns with being single mother. He's also our nephew, my client's nephew. So we will provide one luxury apartment for sure, Ria. Then we can sell the remaining two and split it equally. We have no problem with estate division. They are open for equal this one with priority given to Miss Ria.
Just to get a clarity on it. So when you said that you will be giving one apartment to Ria, is it the Mumbai apartments? So the one Mumbai apartment will be given to Ria, and the rest two apartments will be sold and the benefits of the same will be shared equally.
Yes.
What kind of ownership will we have? Is it like full ownership of the property? Will we lease something? Yeah.
So on that part, we are we'll have offering equal share in real estate, but we are reducing the say in business and commercial matters. So we are reducing the say of Sanjay and Riya in the commercial and business matters, but we are honestly kind of giving 1/5 of the share in real estate. Which means that whatever like Riya wants in like public, whatever she wants to tell, such like her statement in the matters that will not be given much importance. Because the three of us have been running the business for a very long time, and honestly, we think that we know the business in and out.
So let's give it a line view. So India will have ownership of the complete ownership of the apartment. However, in stage of the same or her involvement with the business, per se, the decision making, financial aspect will be reduced, and her words will be of no meaning.
Not no opinion, she will have a say, but not as much as the three of us do. We are also ready to offer the child support and maintenance cost. Yes. So, regarding the movement part, one of the movement parts is moving to the and the rest of your part is moving soon. And that so much the value of the group.
Equally, on the other question.
Among the other students, it will be divided.
Here, we will like this is the complement, the decision making power.
Now, the thing is, so you mentioned that the decision-making power for Ria would be reduced when it comes to commercial matters. This is commercial matters, this is your apartment. Not at all. We entire experiments. Okay, so what I had in mind for those two topics, the business and the commercial context, is that until the asset information is fully finalized, we have agreed on terms, right? We have terms and this, but until the asset information is fully finalized, the rental income should be shared between the price. Until the asset information.
So expand what comments, as I said. So what is the impact, the commercial property? So obviously you have some kind of rent from the sale, because it's a commercial complex, you will have a rent. Am I right to say this? So all this includes you hold the whole rent income, and that comes from the commercial complex, and that will be distributed equally to all these units until the initial of property is done. Is the plan required? I think something of that.
So the way we would implement the same would be that we would set up a joint bank account for all the income. We will now again once again request tenants to provide an internet properties and accordingly it will be split. Now this is just so that since it wouldn't really, have us in financial turmoil until because of the delayed partnership. So until the asset divisions are being finalized, the rent income will be shared. Profit all of them.
Honestly, me, Meera and Dave, right, we have verified the documents of our contributions that we have given to the family and the estate, right, which is also the commercial complex and everything included. We have seen, we have seen the family business and we've managed the family business for over a decade, and we've seen major expansions in vendor relationships. But also I would like to point out that Dave has maintained the commercial complex and he has coordinated rent collection and repairs. So it doesn't make sense as to why all of them should get equal share or equal contribution as such.
What I'm saying is, looking onto the aspect of the management, it's not, overall. We have get wide as a purely on the so that is sometimes just giving the short to the income that's coming from the commercial complex is divided with the siblings. The thing is, obviously, I'm sure that the issue at hand here is that three of the siblings here are, operational in nature of all the commercial complex and the business. The thing is, we have agreed upon helping out here. Yes, I have got to without mentioning, and I have to give solution that I can provide at the same time. But this is just so when everyone stays financially afloat for the temporary amount of time the acceleration happens. Once the acceleration happens, something, a decision like this should be made because we cannot, do whatever we want to we've been given. So it just acts as a safety net for all citizens until the acceleration becomes.
Okay. Okay. What I'm hearing is going to divide equally the rent.
Temporarily.
Temporarily. Until the external audit.
But the acceleration is complete that part. Okay.
Sanjay, you are getting tested, you are asking for equal rent, their terms are finalized. But even when you are asking for equal rent, you must see the contributions that each family has done. See, Dave, since the beginning of the complex, he has been managing it, he has been taking care of that complex. He is the one who is solely responsible for that 1.5 crore of rental revenue that is generating annually. So now, how is it, you're seeking fairness, but how is that fair when someone who is contributing so much to one particular thing is not getting his recognition for that new contribution?
Okay.
I would like to add one thing. Me and Meera, me and Meera, both of us are also not into the complex because that is solely operated and like everything is just with David. He handles it. We don't want to part from that as well. So if we don't want to part from that, it doesn't make sense if you guys would also demand for it.
What I'm mentioning here is that it's purely temporary. Purely temporary. The thing is, asset allocation, the loans are already been available. The only thing that's left is the actual use for asset. That doesn't take that long. Because obviously, we have something that's easily to work with and it will happen in a very expert process. The only question I have is, what is the problem with the temporary? Because it is just temporary, and I understand that they have put a lot of this hard work is so much more expensive, but he has put so much effort into it. I understand it was good rental income, but which is temporary spending, just so we can all say financial.
As if it should, rendering, there is just say, temporary, siblings. Is it for to save the siblings from the financial crisis as it were, right? Until the asset is financed. And once it's done, then, it will be go back to normal.
Say. This Sunday, Canada, due to managing I think, the counter understanding of what we have to see the different operator. And under the chair, because after all, equally, entitled to visit around. So just because the one person or one city has played a managerial role on telling due to which the analysis of preferential claims is not fair. Further, according to them, the state and all assets has to go equally to transfer here. So, being that said, I discussed with Sanjay on what thing we can do is that until the until the GA or until the court has done parties on all the others, can we keep the rental income from the commercial complex deposited in a neutral escrow account? Would that be open for
Just one problem. So commercial tenants caught in the risk have held the rent. So no rental income is coming at this point.
That's why I mentioned in my proposal previously that we would have started requesting rental income from the tenants from the. So I mentioned that. We would basically, request them to resume payment. And then monthly the rental income will be stripped. When it's in the request. So the money would be going to an escrow account, basically, and we would be.
So I think I will do a better version. So basically, an escrow account is like a third party account where the money will be kept. And until and unless the decision is made, the money won't be used to any of the parties. So it will only reach the parties until the decision is made. That's basically an escrow. I think the legal counsel will be the better version. So that's basically our escrow account. So are you ready to put in an escrow account? You give the rent, the code, or mutually, or the siblings agree to divide the property. Will that be good for you? Yeah, thank you. Councillor Naveen, could you just elaborate on what normal here means? So that there's a clarity. Because then we go back to normal. And then we fly them.
So depending on after the access division has been closed, I believe there would be a discussion in the future about how the division of the commercial complex would be because you cannot negate Dave's hard work as well. So temporarily under the asset division, that can be a discussion that can be one after.
I think we can go to the second agenda, the business distribution.
I would like to call the office. Again, I just want to remind that this is a private office where the information shared by the party, the media is going to be confidential. It's not going to leave this room or be conveyed to the other party unless and until the party calls us to speak up. So I would encourage you to speak up and open, and be transparent, which that's what's going to help us make progress here. You can start.
So the thing is, at the moment, I believe that the issue that they might point out from our side is the amount of money I have borrowed from the company which is 2 crore. See, the idea for me is that I have a repayment plan in place that I will propose to them and hopefully they agree to those terms. But other than that, I am happy about how things went about Rhea because struggling so much, getting a profit for herself is something that I'm very happy that all the siblings agreed upon. And we're all on the same page about that. I'm sure that she'll be very happy as I've made decisions on behalf of her today. But other than that, see, now another thing was they mentioned the business and how they were going to split it. The idea that we had was that we would create a family trust. You would basically set up a business or set up a family trust for a business where all 5 siblings are beneficiaries and voting members. But only the active members, which are RF, AF, and Mira, will handle operations. So basically, it separates ownership from day-to-day control, right? So they will manage the business. We can receive annual dividends or profit shares without interfering with operations. Now, the percentage of dividends and the percentage of shares will be discussed upon, with them and their presence. But I believe the implementation of the same can be explained by my policy.
So the media family given the sequence first draft the family plus with legal support. So basically what I meant by that is that we and the other council will come to the register and will draft a family trustee. So that the reason why we are involved in that also that so that the perspective of both the parties can be brought into the it won't be unfair. First is that and then we appoint or trustee or rotating civil trustee. So rotating civil trustee means that the trustee which will support as civil for a limited period he will be looking after the matters and after the same after a period another trustee or another another civil will be appointed as a trustee. Then we set profit sharing ratio and the governance will basically what basis or on what percent will be profits coming to the share and on what basis will be dividend be taken from. In the sense is it for active contribution, is it for finance management? So we'll set some criteria and on basis of those criteria we decide on the profit sharing ratio and finally we register it as and transfer the share of the authority, which I think is a very good. So I think that we handled by the council. I think we will let it be handled. And okay, one more thing I would like to propose is the reimbursement claim from India. So what I would like to propose is that should not affect the shares of high class. So there are one crore medical expense reimbursement to be treated as a creditor's pay and not as a ground to reduce Riya's or Sanjay's shares in the whole family asset. See, they can actually contribute proportion from the estate to prove it, but not before the partnership is formed. So basically what I'm trying to propose is that until the partnership is formed, the claim of 1 crore by Riya on citing the business medical expenses should be treated as creditor. Is there any language to it? I just want to know which all information you want to be concentrated as a social person.
The thing is, also, I think we had one more proposal we wanted to mention to you, but before that, you can mention that I have a review plan that I would like to propose. That is one. The second is that, rather than mentioning the specifics of the proposals, we would like to put forward, we just would like to put forward some proposals for the business, and they mentioned that as an executive. So I would like to mention one more proposal that we could put for the business, which my council would be more, equipped to explain because.
Yeah, so me and Sanjay and we combined, we had a talk about what to do with the business in the next steps. So we ended what we came up. There is not like a final outcome. There can be outcome. So basically what it is that Riya and Sanjay will agree to exit the business. That is now excellent private limited. Over a period of 3 to 5 years, to a family buyouts option everywhere, which again I think would be best drafted by the legal house for the party. And the second 60 years of the company's act of 2030. Or we are the shareholder transfer, whichever they prefer. Now, how we are planning to implement the same is first we'll draft a buyback agreement, as I said, better drafted by us, during the meeting sector. And will include four main points. First is the valuation of SEBI registered bond border under the rules 11 of income tax rules. Second is the first right to represent for the other citizens. Third is the payment of the equal taxes over 3 years and interest rate of 6% per annum for any delay which is possible. Is it clear enough? I have one more point, but it is. Okay, so how we draft it is first and foremost, there will be main four things that will be in the consideration while drafting the buy sell agreement. First is the valuation by a SEBI registered valuer under Rule 11A. I think it is better. Next is the right to refusal to all the other siblings. Third is the payment in equal tranches over 3 years with an interest of 6% per annum if there is any delay. Per se, this interest will not come into consideration until and unless there is a delay in this amount. And the last one is under section 56 of the we will do everything under section 56 to ensure proper national on the section 11. So basically, rule 11 under rule 11 way of income tax rule says that a SEBI registered valuer has the authority to value a company and you know what is worth actual market. So according to that, we will find the value first and then we will decide upon it. If the income tax case is required.
So, is there would you just like go with the brief just of what would be what would you like to be conveyed here now?
So first I mentioned that I have a payment plan, yes, that I would like to propose to them. And then we have to offer that we would like to propose to them about the business.
Would you like to give the details of the business
No, we will be with that.
for the this one you have and the question is
At the time to start What do you think?
So we're still under the current. It's fair, it's valid, because siblings, right? And we would convey whatever the party would like to give up. Because party, if you give us a permission, so let's start, I would encourage the party to be very open and transparent. Because that's what's going to help us make progress and that's what's going to help us come up with solutions, the issues that we have with it. So you can start. Thank you so much for giving such a space for me, talk to you about whatever we are facing. Internally amongst the three of us, right? Me, myself, Meena, and Dave, facing a lot of issues. Issues in the way where I wanted to take a legal action. I wanted to go through the legal way. Dave did not have a say in this. He did not want to say in this. He was neutral. But Meena wanted the mediation. I think that's for both of us driving here, because we wanted to make sure that whatever is happening in the best interest of everyone. Because after all, they're my brothers and sisters as well. They're the same blood, they're the same blood. Also, we have recently received an interest from a major real estate developer in purchasing the 12-acre and Western property in Kerala, which means that they're ready to offer us 15 crores, which would also increase our assets significantly. And
So moving on, adding on to that point, whatever we are saying now, like, will not be told to the other party. So since we are getting this 50 crore valuation from here, we are buying the out their share in liquid cash for the 12 crore valuation. So that we among the three siblings can share the extra 3 crores. So, and another important point is the mutation records, right? They are incomplete, the Kerala property itself. So because of that, these neighbors there are trying to dispute the boundary lines. Again, it's mainly through technicalities and undervaluing the land because of substance.
after all, the siblings over there, I would not want to call them other party. They were brothers and sisters as well. But the fact that, Sanjay withdrew the 2 crores from the family business without proper approval or transparency, we have evidence for that. And we would also want to know as to why that happened, and how is he going to repay us back on that part, because of what happened that it made me take out the waves proportion from the business. Yes, so regarding that aspect, such a proposal, we has a repayment plan for the 2 crore, which was taken by without informing, which we will be discussing in one session. He has assured that he has a repayment plan for it, as well as, we would like to see that because, that has kind of put a pressure on the cash flow, which is leading to delayed vendor payments. I think that would be one of the points where they would want to discuss in the first when they come. So that's fine.
Right, it's not correct. Because confidentiality from approaching for the community. So the point that we would like to discuss for us to discuss about it. One is Sanjay's repayment, that is an important issue. And with other things, we would like you to discuss about the offer that we got. And mutation records per se, we can discuss by saying that you do not come to a settlement here, then this 12 crore property also may be reduced to 10, 9, 8. Please clarify the mutation. So what's happened here is mutation records are incomplete. Since the old owners have died, it has yet to be updated.
Because of that, the neighbors there are disputing the landowners nearby are disputing the mutation record. Once that happens, once they succeed in putting the case, it's going to be another major legal issue. That land cannot be sold, no one can use it properly.
You mentioned that, will action.
No, that's just the disagreement between the three sides.
As well as the university party has a, put on phase-wise, business plan, which they would like to propose in the joint session. So they have, the main plan as well as the alternative plan, for the business. So that will be discussed in the joint session.
We call the. Computer has more. It's quite or-
Okay. So, let's think about the transition. Just to go back, the first issue and revise to the proposal that I put forward. So as far as the unrestricted Kerala property is there, that is what we shared 1/5 and then, this, the responding party is going to buy the shares of the requesting party and they're going to get the value of it, right, in cash, they could have. Whereas for the Mumbai apartment, we are going to get one of the Mumbai apartment. And there is going to be sold and the value will be divided by the remaining rest of the service. So now the issue we have come up with is, the business plan, right?
One more thing,
Yes,
we are also mentioning about the rent.
yes. So, yeah, I'm so sorry. So until the asset division is finalized, the rental income should be, should go into a joint account, which should be shared equally by the servants.
Just a small value, we go to the escrow and then, after the mark,
After the partition is done, it will be divided.
also I give a small value. Kerala property, very interesting. So, told like, one by the divide equity and the bio property will be, 10, I mean, let me say this. Yes. So, how will be the property value? So, like, on what is, how will value the property, I know, my life friends, yes.
All of that began later, because one of the issues we have at hand right now, I think it's better to discuss that. Because we have agreed to it, right, so we're not like going back on our word. We're fine with it. I think it'll be better to be, let you know.
So, while the right session was going on, my counselor and I were talking to each other and I called Ria as well at the same time. The thing is, see, you, Dave and Ria have put a lot of effort into the commercial complex, the business. It's not something that can be just overlooked. I'm sure Achan are very like proud of what you've been doing. And we acknowledge the same as well. So what I wanted to mention was that we were talking about the split of the business. I want to just propose we agree to exit the company within 3 to 5 years to a buyout option. So the technicalities of which, obviously I can only tell you the header of it, the technicalities of which my counsel will be explaining.
So basically, I don't think like I have a better capacity to, discuss the technicality of the thing. So, to expand more about Sanjay's said, so India and Sanjay are agreeing to exit large extent private limited completely over a period of 3 to 5 years through a family buyout option agreement, which will be made under section 68 of the the company that 2012. Or we are a shareholder to shareholder transfer, whichever is your preference. Second of all, so would you like to, should I elaborate on how it should be implemented? Thank you. So first it is draft or buy-sell agreement during this mediation or in the sense that during the period of mediation, not this one second, during the period of mediation. And I do think that we will work together for drafting the thing so that your perspectives are also reflected in it. So it will include maybe four things. First thing, it will do a valuation by a semi-registered valuer. Which is again under income tax return. So
I'm so sorry, the valuation of what?
valuation of the whole company, the company, like its share, what's the actual market value of the company. So it will be valued by a semi-registered valuer. So I think that's very fair and according to the laws. Then there will be a first right to refusal to other citizens. So in the sense, like if there is a dispute or something, and if all the five, we don't know about the future, right? So when the dispute and all the five siblings are not agreeing upon something, the any sibling can have a right to refuse that offer. Is that all? Is that right? Yeah.
Clarity.
Yeah. Sure.
It's about valuation and everything.
Yes.
What is the specific share of each sibling that you are suggesting?
See, what I think what we discussed is that the discussion will be divided equally and it will be made at one by time.
Silent partners. Are you fine with that?
No, see, the thing is, we're gonna just split it equally, and then that, my share, and your share, we're putting on the buyer. So you can buy us out over 3 to 5 years. What I had thought of was that, the payment would be made in three different tranches over 3 years. And if there's any delay, there would be an interest of 6% for an. See, the thing is, rather than being silent partners, because again, you mentioned constantly that you put all the effort. I would much rather give that to you. So that's why I'm giving you a buyout option rather than not before being silent partners. Other, if that was the case, then I could have just equally split the revenue or become a beneficiary or a working member of the company, which I am not doing. I am giving you full control of the business. Happy with that. So I'm sure you got it perfect.
That is fine, but with regards to the shares that the donor is holding, are you suggesting equal shares?
Yes, so initially you could be seen, the valuation will be done, the shares will be split equally, and then those shares, which is my share, your share, will be split amongst you when you want. But the buyout will be there.
So during this share buyout process, will your unauthorized withdrawal of 2 crore be considered?
That's where my repayment plan, which I was going to propose after this, I will mention.
So just a moment. So we'll talk about the total then we can do just 2 minutes. So are you comfortable with what you have said? We are agreeing. Yes. So
Given that we discussed it before,
yes,
Yeah.
So I think Sanjay will do the better question to explain, and I will mention the calculus, but I think from a actual perspective, I think he will be the better question. So Sanjay, would you just elaborate on this and share some point?
So, see, I agree, my fault, borrowing to go to for me, but hence why I'm ready to repay. I'm ready to repay to grow over 3 to 5 years, with a fair interest rate or as to offset according to you. See, the thing is, I'm ready to completely repay it, and the thing is, I would like to realistic, EMI schedule for the same. And any future dividends or sales proceeds that I incur from any asset that we have, we can deduct repayments from the same. If there's any.
Mr. Sanjay, that's what I said. Can you please simplify it?
So it's just a repayment plan over 3 to 5 years, right? So with a fair interest rate or asset offset that they will put on for, right? I just want a fair interest rate. I don't want to repay it. But it can be the better terms because I know I got it wrong and I'm ready to write that on their terms. The thing is, I think it's best if we draft a repayment agreement with the realistic we have a schedule. And I also allow it so any payments that are delayed can be deducted from any future dividends or sales proceeds of any of our shares.
So, Mr. Sanjay, I'm happy that you are acknowledging the mistake that has been done in the past. So with regards to that 2 crores, you have taken it has severely impacted the liquid cash flow of the business, which has severely affected its expansion and its business operation. So, when we speak of just 2 crore repayment, how much percent interest are you willing to pay?
That is what I asked you. Okay, the thing is, I will be adjusting, let's say, again, I want to mention also, I went to the point that I would be, we will appoint a neutral accountant to monitor its repayment as well. Alright, so I will be under at least a supervision to repay my thing. The interest rate can be decided upon.
I think it's specifically decided upon the interest rate when the later period and then this. Because of the valuation. Okay, I need a, I have an inquiry.
What I would put forward is 8%. I mean, we're just offering.
Yeah, so okay, now that there's an offer on the table, again, like my council mentioned, we can discuss this in the later session. Another maybe, what I can put forward that makes it any better is that we can adjust the repayments on inflation.
Okay, just a minute. So we are also discussing about the new person framework. Right, 1 crore. From our side, what we do think is that, as a doctor, he has done what was required at the time of emergency, like giving out 1 crore from, for the medical expense. So, would you like to give it as a regular state and not rounded, thinking around for the reducing areas of unpaid shares? So, we can, again, we want to propose to come to the state, but not before the partition. So, we need to order time before the partition, can that be termed as a creditor's sale?
So what you want to do is basically, during the partition, Veera will get the said 1 crore share in her estate.
Not actually, it was like, Mira, 1 crore rupees for which is reported. But it will, it won't happen until the party is actually complete. After the party is complete, Mira's, 1 crore rupees, reportedly contributed by all the rest of the, citizens. And we given to her. That should not be provided by the that should not be a reason to reduce the share of the.
Councils, so sorry to interrupt. But as there is time constraint and we have to end the session, the discussion about the medical expense of Vida's 1 crore can be discussed in the next session, the work sessions. As well as any other queries or clarities is needed, or any other, concern has to be addressed, can be done in the next session. We are going to proceed with the closing statements. Let's keep it brief and short as possible.
So thank you parties for coming to mediation and choosing mediation as a process. I hope it has been fruitful and helpful for both the parties here. Yes. So what I saw today was how, we are in clear data to, the silence and more for into the music piece. That's what I saw. I saw both parties doing creative proposals to come to an agreement to the level. And thank my co-mediator for facilitating this process smoothly. And also like to add on to say that if you choose to do more session in the future, please do so because it will help reduce any disagreement and ensure there is further trust when with that I like to
We really appreciate the parties coming here today to sit here and discuss the issues between us and things. And I'm happy that they constrain the relationship between the five siblings that are here today and in their absence as well. I'm very happy that we have come to some terms and some agreements. I hope so both the parties are happy with it. All the siblings can, go on, move forward, keep the family business alive and family name alive ahead of us. So the requesting party will start with it. So please make sure, keep it brief and short.
So, that always told us to keep the family together.
We have 2 minutes, so 1 minute, and close it up.
That always told us to keep the family together, And I think that's exactly, what we try to do today. And I did what I did, I gave the option I gave to basically, I hope they're looking at you that. I hope they're looking at us with a smile on their face. So I'm happy with the fact that whatever we've done today has come up with a fruitful solution. And I hope that, we can all start being happy again together, actually start spending time together again, because that has not happened for the past, 1 month. So that's pretty much what I wanted to mention, and I think my council will start asking questions.
Thank you, Sanjay, for that comment. Thank the leaders for connecting the session with the social and also the parties who have come with the collaborative approach. So as a legal counsel who has seen the sort of things like this, I was actually hoping that, some worst case scenario might happen and that might, damage the whole sibling relationship. But fortunately for us, nothing like that happened. The parties are well aware that the relationship between siblings should not be affected very much. And even though we reached to some solution, we reached to some agreement, some article agreements by both the parties, I do think that we have some more things to discuss, which absolutely can be discussed in the upcoming session. And as you know, like, when both the parties entered the room, you had this much things to solve. Now we have at least come to this point. Now I really hope you come to this growth and, amicably solve any issue that we have through a mediation rather than going for litigation. It takes years and years to do. So I would like to thank and I would like to see the other party and the council in the upcoming session for having constructive dialogue. Thank you.
Firstly, I'd like to thank the mediators. Thank you so much for being here, for helping us come to such a level, or like a middle ground where both the parties, my brothers and my sister could like just come and come to a common ground. Sanjay, it was amazing. The fact that you came up with such ideas, it was amazing. I think it would be something very nice if we had you on our side and you would also help us do much more better in the future, provided that whatever both of us want, we come to that particular conclusion. Thank you, council. Thank you, council. That's more.
So I would like to thank the mediators firstly for making us feel comfortable to share all our problems and concerns. I would like to thank the requesting party for being so collaborative and being so open-minded with suggestions. Now, I'll be ending this very objectively to few problems that we can address in the coming mediation sessions would be again the interest for the repayment as well as the proper division and valuation and such problems. Thank you. Then the mediation concept as
more comments I expect from Madam Gita Devi because she is our national market trainer and she is the expert mediator. And also person. He is getting lot of different course. And mediation concept in Professor Malika so many informed me the other day about the mediation. I was very and the first for itself, I accurately is prepared to participate in the mediation contest. And the way meets the opening remarks and the way meets the requesting party, participating in the responding party, and responding party also persuading the requesting party to share their own view. So that everybody keeping their personal interest and we felt that neutrality among the mediators and confidentiality aspect and 2 or 3 points that what we have noticed and we have said that the responding party try to persuade them to concede to your demand. At the same time, you are also forgotten something that your personal interest in the business. So what you did in the business, when you left the job, foreign job, came here and settled here, you are involved in business and everything. But you did not persuade them that they should better be instead of 1/5, they should have take 1/4, 1/3, 1/6 or 1/7. So that your involvement and that could have been persuaded better also. At the same time, you also pay payment of that medical expenses. Mira paid 1 crore for the treatment of this. But you both failed to persuade each other that the Mira's payment should be made first. First, the expected result should be, you should have paid out the Mira first. Because he has paid 1 crore. Instead of that, you are not ready because now you are both are asking that rent accrued from the complex to be put in the account, mutual account, SQ account, SQ account. Instead of that, whatever the amount that has been in the SQ could have been paid to the Mira. No. So we are the came to the help to save our parents. We should come forward now. So these are the aspects of it. When you are making your presentation good, you appreciate that. So these are why these things have not come forward, come from your side, because you are representing the Mira. You are unknown. So you are unknown representing the Mira. More when we are representing a party who is not present here, but protect their interest first. Then our personal, whatever they want. Whereas from your side, you are already trying to fraud from the and then you want to pay it to your council 6%. Now you are paid for 8%. Yes, for 2 crore intervention. It's also you are not opposed. So now the mediation is not completed now. But then now it has to go forward. What else then we could not reach, no agreement there. No. So your offer of 6% and their other offer of 8%. It's almost near, I think it's a considerable. Madam, very considerable. So these are the observations that we, about the mediators, what we neutrality, opening statement, persuading, and confidentiality aspect that you are all making. It's very tough for a student to be a mediator. Because if you are leaking something about them, and they are telling they want to patent 3 crores. So he wants to pay 2 crores 3 and 4 years. And you want to lock the business in the complex here, rent should be kept in the escrow. There should not be any difference. These are all the things we have really seen in adjudicating the matters in the court. Yes, I have adjudicated about more than 47 thousands of judgment I have written for over 30 years of my teaching. These are the things will naturally come and we enjoy that kind of thing. The person who will be ready to pay whatever the money under the guidance, he will sell the property for black money. That component he will keep it inside. Only white component he wants. So these are the things of the trade and the when parents come, so both the parties will play emotionally also. So that kind of things we but overall, by seeing your presentations and all those, it was nice to be a part of this kind of mediation. Congratulations. Marks is concerned, that will be there because we observe, we perceive. And by seeing your performance, by seeing your body actions, the way in which you are put forward, and what are the things you told yourself. So those are the considerations we will come to our mind. And we expect that something from you that is not coming. Expecting something from you. Little bit here and there because it is your first time it is for a mediation. that will come. Even as a professional advocate, like they will be very master, they will prepare their work, they prepare the clients in such an very difficult. Very tough job for a mediator, to persuade the parties. Because they also used to do so many mediations. I was sitting in the high court, persuading the APS staff. APS staffers, we were persuading the girls, the love cases. Intercaste love cases. It's very tough to persuade each other, and we must be there with security and all this. Persuasion will work always. The main agenda of the video. Without hunting the above. Better you the mediator will be on your counsels. You also try to help your client to see that the better interest of your client is.
Competition. I don't know which class you all are in. As students, preparation, confidence is something which is very important. Then there are many things which I would like to comment in the sense, the way you move into this mediation, you have thought of it as a collaborative effort. But I'm going to be critical here in saying five or six points. The commentary is thinking that it is going to be collaborative effort. But it is complicated, as just mentioned now, each one of us are fighting for our right. Well, what is there, what I want, I is more important in any negotiations. So here we are proceeding from the opening statement that we are going to be collaborating. To make it very easy for the mediators, so that you know. So you come up with that, render this process of mediation. I'm thinking about your live mediation. So my observation is on that. I'm sure you're not going to observe any mediation, but you've conceptualized and done it. That's excellent work. So first of all, I'd like to appreciate or your behind for all of your doing so excellent in the. So when we are competitive, we will never live an inch. That will go where we are moving forward. So the role of a mediator will shift from competitive parties to collaborative. It's a Hercules task for the mediator. And that is where we use a lot of private sessions. So that is one thing that I want to observe. The way you are entered in this process is more of a collaborative. So you're coming here with solution oriented. So the first impression I as a mediator got is this party is going to resolve the matter after. So it's only when give and take, thoda kuch, thoda zyada, thoda kam, thoda zyada. Okay, now is what how we are investigating. That is what we are going to do. So the one difference which I found in the life mediator is easy, I want to start with. Second, I'm saying this is one. I think the lawyers play the dominant role, whereas we as in the mediation, the parties are big on. When you look at the definition, we look at the parties in the. I would say this voluntary. I like the way you asked, do you want to be your voluntarily participating? As she said, when you're complementing each other, when you're doing co-mediation, you can't repeat things. So I like the way technically moved to ask whether they are willing to participate. So, whereas both of you are talking the same thing. I wish to really elaborate a little bit more on not the voluntary aspect, but confidentiality. So, what is spoken here? This is without prejudice to your rights in the court. They are litigating, and she wanted to go, Anna wanted to go for litigation. So, you are aware of that, they want to go for litigation. So, whatever said here will not go there. So, that is something which helps parties open up and express and share. Here, I think as competition, as there are rules and you have come with the way you want to submit it. So, the question was that a little bit more elaboration on confidentiality would be important because the confidentiality aspect and the two factors are very, very key factors in the That's second observation which I wanted. So when you're talking about party centric process, a little bit more role. I saw in the latter part, second half, I saw the parties contributing, but I think the lawyers were dominating and more as the dedication role which was and were directly negotiating. So it was effectively silent spectators or mediators became silent spectators. So now I would suggest that you know that mediator asking or coming to the whole process. Somewhere one of you mentioned that the control, you are in control of the process. No, ma'am. No mediators. Mediators are in control of the process. We listen actively. When I say actively, we listen to our eyes, ears, and our heart. So you understand the empathy factor. You saw how things were going on. And I like the way finally she addressed him as a brother. So she was incorporating them as a family member, whereas he spoke very everything. Let us talk about father relationship. Addressing each other as brother sister is longer as in that manner. So that would be in a better way of if I'm jumping, but we are different. So if how you involved in such state, you have no choice. Because it is going on. Big fight is going on, big also. There is negotiation is happening. Ask the big questions. Example, ma'am, said, could you restate? Instead, you said, help me understand you better. This is what you have said. We clarify here. Then you are understanding them and their problem. So that is how we are going to show that restate instead of word restate. It is cutting short the process, but instead of that can we use expression where they are showing that you understood their problem. So if you could reframe after each one of them, I don't know how your rules of your computation, but if you have taken 2 minutes, 1 minute to reframe what they have said, you don't have to make people a list what they have said. But if you could identify, this is the problem that you have, your brothers and sisters, this is the problem. So this is what we have understood. Correct people and wrong. After they finish the arguments of the people, I think that you are with them, you are listening to them, and you are understanding them and the problem. So that is the way when we don't have the way things are unfolding, because you have no time to reflect, but you should have taken control of the process. So process is in your hands, solution is in your hands. They came up with a solution, but we did not have, we did not have a role. They came up with options. So when you're asking them, you should have asked more questions on options, but they came up with them already that is good. Questioning skills, I already said that. Then what you are using as a mediator, the role of mediator, some words are negative. For example, this Sanjay's withdrawal without consent. That has angered them. That is what has led us coming in down. We should not repeat. As mediators, don't repeat. Can we use a substitute word for that? Without consent, that's a negative word. Say you've taken money, you're going to repay the amount which was taken without your consent. Can we repeat or reframe that word better?
The money that has borrowed.
Stop. Sanjay withdraws certain money which belongs to the family assets. You are not taking him without informing them, without knowledge, without consent. So you're not pointing fingers at anybody. So the role of a mediator is to remove the state. This party will be accusing him that he has withdrawn the money. That's what is what. He has taken the money without consent. Actually, it was fraud, is what they were accusing. So without pointing the finger to him, how will we bring in that? He was kind enough to say that yes, I've admitted my guilt and therefore I'm ready to do this. This is some of the techniques which you will learn. Sure, it took us some time for us to come into this, and you're doing all this without understanding or rather practical experience of learning with this. So these are some of my observations here, and lastly, I want to talk about improving the marks. That should start from here on. As a mediator, what have you observed? This is the problem. This is the way you're arrived at the conclusion. If there are any thing that you want to add, then you can do it. Or you ask them to speak, then you will do it. Your time management, you had the time period, you could have started there. And you effectively said that you have less time, you're going to postpone things. That was an effective way. I also would like to be curious to you, when you're concluding, what have you achieved so far? See, this can go on, there are several mediation, day of signing this contract. It's failure. Something they have gone back. So in comparison, what they have achieved, there were 5 points which they were disputing or other, they were very clearly categorizing this financial, it is, business control and this single word, real estate is what he said. Now with this, what we have achieved, what more has to be achieved? So in comparison, इतना सा achieve किया, इतना छोटा सा है आप achieve करने का, they go back to the sense of, oh, we have achieved so much. Start highlighting that there's so much there for us. It will be an effective way. This is only just to add, you've done an excellent job. But if you can, perhaps you, by the time you finish the course, you will be a better mediator than honor. Thank you very much. It was excellent to be here. Your participation. And for us, it's like, you know, invited, and we find mediation, they take a what's this, one more, after 7 you have done, first training. First, not, how you play, how you like it, where is the day, where is that, line by line to draw something. All in the same. But yet, you were able to understand where the neck goes, where the eye goes, where the arm goes, where the ears is. That's excellent comment. Excellent statement.
That we are first mediation. First mediation.
Hey, that's excellent. Why do you not a great.
So I had plenty of questions to ask, but of course, I would only say this: you can be a good mediator if you're a good lawyer. See, legal content draws a lot of issues in mediation. If you have not strengthened yourself with law, you cannot put across a lot of issues here. Lordship and Madam have already spoken about how a good lawyer goes to the good details of the facts of the case. Lordship mentioned to you where the facts have to be present. Madam spoke about procedure. But I would emphasize on content because that is something that you must always understand. So I hope you had good coaches, you had good teachers who taught you family law, because you were only speaking about succession. You did speak about companies law, but you did not speak about corporate governance. You did not know the distinction between buyout or release deed. I did not know what buyout meant. So on the content side, I think you guys must prepare well. Because see, as law students, please understand that is where your core research should be. If you come very well with the content part, I'm sure you will be able to mediate well. You will be able to analyze issues. Both one, factual issues are very important, but applying the legal issues make it a lot more sensible, right? So you must understand that kind of a process. So if you don't do that, see, family law is not everyone's favorite, but it is company law. So at least we must study that pretty well, right? See, for example, you mentioned about escrow and so on and so forth. These were good ideas, but mediators should have asked for more details. Right? These are very specific. See, lawyers don't work on superficial aspects. We don't work on the cloud. We must work on the details of it. Immediately, the next question should be: where are the details? How do you do it? Please understand. None of you spoke about succession certificate. I don't know how you divide that land in Kerala. Right? Without title, how do you sell? Right? These are very important aspects of legality. Once you bring legality, let me tell you, your mediation will be far more. I think the audience will enjoy, the judges will also enjoy, because there is a flair of government. Right? Properties cannot be divided by successes without applying for a succession certificate. You must get title before you can even divide. Right? So all of these are critical aspects. If you learn, you'll be much better lawyers, right? All of us. Did well.
Always the opponent takes the weakness of the other side and punish. That's the reason they don't back up their merit. They will only enlighten it, declare it of the opponent. So they are trying to sitting aside, will enjoy their my attacker is arguing. That kind of enlightenment. That's the reason why profession like advocacy is there practice. We cannot other than sudden come and learn and so we have to practice. Unless you practice, just like a sport. Doctors also, yes, my daughter is after she was operating 25 minutes for a SNCS procedure, cataract operation. Now I put her to the one or two hospital in the local. Now she came down to 3.5. Just 3 months before she was taking 25 minutes. Now she is taking 3.5 minutes. And she has operated more than 155 cases. In practice, we improve. These are the things we become like this. And the profession like us is a learning process. If you take, if I cannot, I am a fool if I say I learned everything. It's a learning process. And everything we interact, we learn. The experience will teach a lot of things. That's the maturity that will come up by practice. Thank you.
Why is the mediator not ask for private water, why do you wait for? You are under to ask for private water. Happening. You start repeating the second time in the start, within the 30 minutes you must count. So can we have a private focus in each of them? You would have done that, and not waiting for her. Number one, the Adam asked for it. But when Adam asked for it, he started with it. Why? Where did the request come from? They wanted, so they had something special to say, something different, confidential, they were with you. As I said, as the professor mentioned, I'm looking at the word process. But yes, that is what we should, because our role as a mediator is process facilitating. So when the request came from there, that's one. Second one, you said immediately after the opening statements were over, you should have summarized this is your concern, this is what it is. Now, can we hear you are separate? You could have started it in that manner. So that you could go in the privately, you could have done answer findings. And as the professor mentioned, for a mediator, understanding the law is very important. And how you facilitate what questions you ask, how you take the process forward is very important. As the time is short, in 1.5 weeks doesn't work at all. 1 hour you have taken to understand the party and to know what they want and what they don't want, and they'll be accusing each other. The first hour you were Arnav complaining about Sanjay withdrawing the money, Sanjay complaining about how Arnav is bossy, controlling, and all this. So that's where you have time to private sector getting into this. This doesn't happen the day you have done. But yet, well, excellent job. Thank you. It's good to watch you all. Looking back to those days when I was a student.